This is New York Times versus United States, which took place in 1971. So the case background, basically the case took place during the Vietnam War. This was around the end of the Vietnam War, and by that time the war had really decreased in popularity. This took place during the Nixon administration, and in the administration, the Secretary of Defense, Robert McNamara, decided to commission a historical account of the war, all the way back from World War II, on how the U.S. actually ended up getting involved in the war. David Ellsberg was a part of the top secret study, and he leaked it to a New York Times reporter. So the New York Times published the leaked information called the Pentagon Papers, and the newspaper was titled Vietnam Archive Pentagon Study Traces 3 Decades of Growing U.S. Involvement. Nixon then ordered the publication to be halted for the reason that he claimed that the publication violated the Espionage Act of 1917 and that the papers contained information that posed a great threat to national security. And in a matter of days, the case had reached the Supreme Court. The applicable law in this case was first the Espionage Act of 1917, which stated that whoever, for the purpose of obtaining information respecting the national defense with intent or reason to believe that the information to be obtained is to be used to the injury of the United States, shall be punished. And then the First Amendment, which was basically the freedom of speech clause and the freedom of the press clause. The constitutional issues in this case was that the Espionage Act is really unclear as to what it prohibits exactly, and it's also unclear under what circumstances it would impose punishments on someone that communicates secret U.S. information that could do damage to national security. The Espionage Act also does not authorize the government to stop the publication of a document. It only states criminal penalties to impose on somebody that has already discarded national security information. The idea of prior restraint, which would be halting the publication of something before it has actually been published, is extremely hard to get. Other than that, or for this reason, in order for the court to side with the government, they would have to prove that the release of the papers would cause serious and irreversible harm to the country, and the reporters distributed the information with malintent for the reason to get that prior restraint. So the constitutional questions would be, number 1, did the New York Times violate the Espionage Act? And then number 2, was President Nixon justified in stopping the publication, or did he violate the reporter's First Amendment rights? Some possible solutions would be that the court could side with the government because the United States was still kind of at war at the time, and the Pentagon Papers could also do serious harm to the country, and they would support the halting of the publication. Or the court could side with the New York Times and say that the First Amendment rights of the reporters were violated by the halting of the publication, and that the reporters did not publish the information with the intent to actually harm the country. Or the court could rule that the reporters violated the Espionage Act and they could go to jail or be fined. So the actual ruling was 6-3 against the Nixon administration, and they declared the prior restraint that Nixon had issued over the New York Times unconstitutional. They said that the president's attempt to prevent the publication was a violation of the First Amendment freedom of the press clause, and the ruling upheld the New York Times' right to publish the classified information. The reasoning behind the decision was really unique because there was actually 9 different opinions on the case. Even within the majority opinion, there was basically 6 different opinions for their ruling. So, for example, Justice Hugo Black rejected any prior restraints on the press. and he stated that only a free and unrestrained press can effectively expose deception in the government. Justice Byron R. White refused to grant censorship authority to the executive branch without authorization of Congress. Justice William J. Bennon Jr. held that censorship was allowed in certain circumstances, but the claims of harm to national security in this case were insufficient. So basically, the United States side had failed to prove that the papers would cause serious and irreversible harm to the country. Justice William O. Douglas argued that the Espionage Act did not support the government's case, and Justices Stewart and Marshall argued that the court should not grant censorship power at all. So these are just some quotes from the concurring/dissenting opinions that I found. So let's see. So with all respect, or I'm reading the Justice John Marshall one. So with all respect, I consider that the court has been almost irresponsibly feverish in dealing with these cases. So also the main reason for the dissenting side was that the case had been brought to the Supreme Court and was decided on way too fast for them. So yeah, and then of course, Chief Justice Warnberger said, of course, the First Amendment right itself is not absolute, as Justice Holmes did so long ago pointed out in his aphorism concerning the right to shout fire in a crowded theater if there was no fire. And that's referring to the Schneck versus United States, the Schneck versus United States case in 1919 that I'll talk about later. And then Justice Hugo Black said that, in my view, it is unfortunate that. So the impact of the ruling was really unique in the sense that the case is widely considered a victory for the free press. The per curiam opinion establishes that in any situation where the government wishes to censor, it would be a difficult task to convince the courts to issue the necessary legal orders to stop the publication of something ahead of time, the prior restraint. But the victory is also seen as ambiguous for the reason that although the court supported the right to publish, for the New York Times, there was no clear, reasoned majority opinion. So the fractured majority opinion failed to establish when, if, or how a prior restraint can be imposed, and this leaves open possible government censorship in the future without stating in what conditions the First Amendment would allow it. So the first similar case I have is Neer versus Minnesota that took place in 1931. In this case, the Saturday Press reporter Jay Neer accused local officials of being affiliated with gangs. The officials in question wanted a permanent injunction, which is a final order from the court that a person will refrain from activities permanently. The officials claimed that Neer violated the public nuisance law, which stated that any person engaged in the business of regularly publishing or circulating malicious, scandalous, and defamatory newspaper was guilty of nuisance. So the question for this case is, did the public nuisance law violate the free press provision of the First Amendment? In the case, the court ruled 5-4 in favor of Neer and declared the public nuisance law unconstitutional. In the case, the court also established the constitutional principle that, with some exceptions, the government could not censor or prohibit a publication in advance. The other case is the Schneck versus United States case in 1919. Schneck was a leader of the Socialist Party, and he sent literature to recently conscripted soldiers suggesting that the draft was a form of involuntary servitude and it violated the 13th Amendment, and he encouraged them to desert the draft peacefully. So, for that reason, Schneck was convicted of violating the Espionage Act of 1917, but Schneck appealed on the grounds that the Espionage Act violated his First Amendment rights. So the question would be, did Schneck's conviction under the Espionage Act violate his First Amendment right to freedom of speech? Question mark. In the case, the court ruled unanimously for the United States, and the court held that the Espionage Act did not violate the First Amendment and was an appropriate exercise of the Congress's power in war. The case also established that the First Amendment does not protect speech that creates clear and present danger, and that the Congress has the power to prevent. So one way to remember, which is really easy, is just that 6-3 ruling in the case, and then the word or phrase, I guess, NY, and then time has 6 letters, and then USA has 3 letters. So New York Times won over the US in that case. And then the other way to remember is, if you remember the phrase New York City was the first capital of the United States, you can take New York from New York City and put that into the New York Times, and then the first for the First Amendment right, and then the United States at the end, and you can put like was violated by, and then put the United States, so then altogether the phrase would be, or like what you remember from that phrase would be, the New York Times First Amendment right was violated by the United States. And this is my works cited page.